So, as I mentioned earlier this morning, one of the objectives of this program is to provide you with all the knowledge and tools to serve as a director in this a very important element in this puzzle, which is Delaware law. And last year we had Vice Chancellor Travis Lasseter, who had written the decision on trade-offs, which is a very important decision for the venture capital community. And this year we've invited Chancellor Chandler, who is now a partner at Wilson Sonsini. He is obviously one of the leading thinkers in corporate governance, and having been a Chancellor of Delaware, it can't get any more knowledge on these topics. So with this, I want to introduce him and let him have the keynote on this topic.
Good afternoon. I'm told I have to stand pretty much still when this is being recorded. That's not my usual style. Even though I used to be a judge and you had to be planted all the time, I tend to also teach a lot of classes in corporate law, and I like the pace. So I'm going to try to resist that and stay in one spot as best I can. So first, let me thank the Rock Center and Stanford for inviting me to be here. I had actually written some remarks, but I've changed my thought about this. I think this is a group that might benefit more from a conversation with me than they would from listening to prepared remarks. So I'm going to try to do that. I want to thank the Rock Center and Stanford Law School for inviting me to be here. This is a wonderful program. I've sat through it all morning and just learned so much from it. And I'm pleased to see so many here from the VC industry taking advantage of it. The other reason why I'm particularly grateful for the invitation to be here is just because of the energy of this place. Every time I visit Palo Alto, Stanford, Silicon Valley, I'm just so impressed by the energy and enthusiasm of this whole location. It's infectious, and I try to take as much of it back with me to the East Coast as I can. And of course, the third reason why I'm particularly pleased to be here is because you have wonderful weather here. I will just tell you that I left Delaware with 2 inches of ice followed by 8 inches of snow, and today's high temperature in my home is 19 degrees. So you cannot know how happy I am to be here with you. Unfortunately, I have to go back tomorrow, so that's the only bad side of this, but I'm going to enjoy this weather as much as I can. So, as you heard, I left the court about, almost 4 years ago, 2011. June of 2011, I left the Court of Chancery. I'd spent over a quarter of a century on the bench in Delaware. 22 of those years on the Court of Chancery, 14 of them as the Chancellor or Chief Judge of that court. And so I thought about what I might talk to you about today a little bit, and it seems to me that since I've been with the firm, and we opened an office in Delaware, Wilson Sonsini opened an office, actually 2, one in Georgetown, which is my hometown area, and one in Wilmington, which is sort of the center of the corporate law universe in Delaware. And gradually we're building a team of expert Delaware lawyers, all expert in corporate law, as you might imagine. And the firm expected and hoped, and I think that's what we're doing, is creating this resource within the firm of Delaware law experts who can sort of bring that perspective of Delaware expertise to the firm and to its clients, but who also might, in sort of a cross-pollination kind of way, bring to Delaware an understanding of the valley, of Silicon Valley, and how it works and how it operates, and how the economic engine of entrepreneurialism here flourishes, and help perhaps Delaware understand a little bit about the business model here. So that's the sort of the logic or the raison d'etre, I think, for the firm opening the Delaware office. And it's worked, I think, very well. So what I thought I'd try to do for just a few minutes today is sort of demystify Delaware corporate law. Because I think there is some misunderstanding. I think, frankly, it's both ways. I think Delaware misunderstands Silicon Valley and what you all are about here in a little bit of a way. And I think there's also some misunderstanding in the opposite direction. So I'm going to try to demystify a little bit about Delaware corporate law and how it might affect you in your daily lives, particularly if you're serving in the capacity of directors of a company that's incorporated in Delaware. And most companies are incorporated in Delaware. And let me say at the outset, it doesn't matter whether your company is a private company or whether it's a publicly owned and traded company. The rules are the same. The rules of the road are exactly the same. And so what you need to know is identical in both situations. So you should never lose sight of that. Your duties and responsibilities do not change if it's a private company or if it's a public company. They are identical. Now, before I do this, and before I talk about some of the sort of fundamental principles that you need to keep in mind, I was thinking about it on the way here and trying to think about ways in which, despite these sort of misunderstandings or disconnects between Silicon Valley and Delaware, that there actually are a lot of parallels. A lot of similarities between Silicon Valley and Delaware. Not the weather, put aside the weather, but in a lot of other ways. So for example, let me sort of use a linguistic or rhetorical trick with you. Because the area of Delaware where all this corporate law stuff goes on is actually part of what's known as the Brandywine Valley. The Brandywine Valley. You're known as the Silicon Valley. And your industry here is in technology and development and software and all those things that you are about. And Delaware's industry, its industrial niche, if you will, is corporate law. It's the major product that it exports. More than cars, more than chemicals, more than credit cards, more than chickens. They grow a lot of chickens in Delaware. Corporate law is the major product. That's the industry. And it's all generated and produced in the Brandywine Valley. So what does the Brandywine Valley have in common with Silicon Valley? Well, first, we both got started the same way, as agricultural areas, predominantly agricultural areas. In fact, I think your valley was originally called the Valley of Heart's Desire before it got the moniker Silicon Valley because of all the groves and orchards that were here. Well, Brandywine Valley was called the agricultural breadbasket of the Revolutionary War. It's where all the flour mills were located along the Brandywine River. And those flour mills generated all of the flour that fed the Continental Army, Washington's army, during the Revolutionary War. They also were the site of many paper mills and generated the paper that was used to print the currency that paid the Continental Army and that was used to write on in the form of the Declaration of Independence and the Constitution out of the paper mills along the Brandywine River in Delaware. So there's a similarity in terms of both valleys in that way. Another similarity is that we both were kind of catapulted to prominence, transported to prominence by historical accidents or by happenstance. In the Brandywine Valley, that happenstance or historical accident was Woodrow Wilson, the governor of New Jersey, running for president of the United States, and in the process, ceding virtually all of New Jersey's corporate prominence, because that was the locus of corporations and corporate law then, ceding all of that to its nearby neighbor, the Brandywine Valley in Delaware. Likewise, the Silicon Valley transformation occurred. Its transportation to prominence came after World War II, frankly, with Stanford, investing a lot of the post-World War II dollars in technology, in iconic companies like Hewlett-Packard and other technology companies. And that sort of correlated at the same time with the happenstance of the venture capital community settling along, what is it called? Sand Hill Road? So those sort of events kind of transported these agricultural valleys into something very different. They have other things in common. They're both very geographically compact. Both valleys, Brandywine and Silicon, roughly 30 miles in every direction. They also have another similarity. They're characterized by clusters of knowledge, information, shared experiences, and expertise and an innovative and experimental sort of culture that exists within both of these valleys. Both valleys have sort of what I call repeat players. That is, people who are familiar with each other, know each other, connect with each other, compete with each other, but also cooperate, relying on that same similar background of experiences and expertise. Very competitive and entrepreneurial in both industries, both in the Silicon Valley and in the Brandywine Valley, always trying to keep ahead of the competition. So they share these similarities. The last one I'll mention in a lighthearted way, the people in these two valleys tend to have a real affection, abiding affection for good tasting spirits, like wines and things. You have your valleys producing your wine. The Brandywine was noted originally by the Dutch for producing excellent brandy and gin, the Brandywine River, and of late, craft beers. You might have heard of Dogfish Head Ale 90-minute IPA. So we each have a little similarity there as well. But beyond these similarities, I thought what I would do first is sort of describe for you in the industrial niche of the Brandywine Valley is this corporate law engine, this engine that exports this product. And the players in that are the corporate law lawyers who all operate in that Brandywine Valley area of Wilmington, and the judges who make the law, and the legislators and governors who also make that law. But there are certain just really, I think, very fundamental rules about it that you need to keep in mind and to think about. The first one is, and it's kind of what I call the first principle of Delaware. And that first principle is our corporate law is director-centric. It's director-centric. It locates the power and authority to manage the business and affairs of a company in the board of directors. In the board of directors. Not in its shareholders, not in its employees, not in public perception, not in Glass Lewis or ISS, in the board of directors. That's where the power and authority to manage the affairs of the business is located. And it's located in the entire board as a collective group of people, not individuals, but in the collective group. That's the first principle of Delaware corporate law. Now, that's true predominantly of all legal regimes in America, but it's especially true of Delaware corporate law. Now, the second thing you need to think about is, well, is that power unlimited? Do those directors have carte blanche? Can they do anything? No, they can't. Like all power, it has constraints. Those constraints are the duties and responsibilities that are imposed on the directors of every Delaware corporation. Where do they come from? What's the source of those duties? Well, there are predominantly three. One is the marketplace. The marketplace imposes certain constraints and duties on you that you can't escape. It also is the source of what I'll call certain social norms. For example, we want to do the right thing. I happen to believe that directors, fundamentally down deep, want to do the right thing. So those cultural norms or social norms are one form of constraint on your power and authority. The second set of constraints, that is duties that are imposed on you, comes from the federal government, the regulatory agencies, the SEC, Congress. Think Sarbanes-Oxley, think Dodd-Frank, think the Securities and Exchange Acts. All of those, layer lots of duties and responsibilities that directors have to be aware of and hopefully have good advisors to help them navigate those duties and those rules. And those rules tend to be very prescriptive, very linear rules. They also tend to be very episodic. That is, they come in waves. Typically after some economic crisis or financial crisis, you'll have a wave of federal regulations and rules and laws. The third source, and that's the one I want to focus on today, is state law. State law provides another set of responsibilities and duties that apply to every director, and in this case, of every director of a Delaware corporation. Now, those rules, I like to think, those state law rules imposed by Delaware, aren't as linear. They aren't as prescriptive. they tend to be more broad, commonsensical rules of the road, sort of standards of behavior and conduct that's expected of directors. So that gives you room for some flexibility, for some creativity and innovation to address them. It doesn't mean you can escape them, but it does mean that the Delaware law rules aren't inflexible and prescriptive in most cases. A few are, a very few. So that's rule number one, director-centric. The second fundamental premise of Delaware law, and I really call this the categorical imperative of Delaware corporate law, is something called the business judgment rule. And I'm sure you've heard of this rule. If you're a director of a Delaware company, you should love this rule. You should embrace this rule. You should adore this rule, because this rule is meant to protect you. And here's how it works. The rule, classically stated, is simply this. It's a presumption that you as a director acted in an informed way and in the good faith, honest belief that you were doing what was in the best interests of the company and all of its shareholders. Let me say it again. It's a presumption that you as a director have acted in an informed way and in the honest belief and good faith belief that it's in the best interests of the corporation and all of its shareholders. What a powerful rule. That's the presumption that you as a director get. What does it mean? It means that if it applies to you and what you've done, no judge is going to second guess you. No jury is going to second guess you. The judge is going to say, as long as there is any rational purpose that that decision was meant to serve, it's okay with me. It's fine. I'm not going to second guess it. I don't care whether it's reasonable. I don't care whether it was a successful decision or action. I don't care whether it was a risky action or decision. Foolishly risky, I don't care that. I don't care if it was stupidly risky. If it has any rational purpose, that's all I need to know. I'm satisfied, and I'll defer to your judgment as the director. That's a powerful, powerful protection for directors. Now, why would judges want to do that? Why would they have a rule that just automatically defers to your judgment and decisions like that? It's very simple. They want to defer to you. They desperately want to defer to your judgment. Why? Because you're the experts. You're the people who know what you're doing. You know how to run a business. You know how to create greater revenue growth. You know how to refinance a business. You know how to sell a business. Judges don't know the first thing about that. They don't know the first thing about it. If they did, they wouldn't all be public employees. It's that simple. Just like you wouldn't want to judge fixing your car, and you wouldn't want to judge operating on you, you really don't want to judge running your business. And the good news is, he knows that. She knows that. They want to defer to you. And that's what the business judgment rule is designed to do, is to avoid judicial second guessing. It's designed to avoid ex post judicial umpiring, where they're calling balls and strikes after the fact, and where they're using hindsight and hindsight bias to second guess your decisions. That's what we don't want. If we did have a system like that, what would it mean? It would obviously mean that you as a director would want to take no chances, no risks. The only decisions you'd be willing to make are ones that you were guaranteed what the outcome was. Why would you take a chance otherwise? If some judge is going to second guess you after you've done it and after the events occurred. So it would have that effect, which would be a wealth-depressing effect, as you can obviously see. And the second thing it would do, it would mean, I don't know about you, but I wouldn't want to be on a board where I constantly had someone in a black robe second-guessing my decisions based on hindsight. No thanks. I don't think I want any of that. So the judiciary designed the business judgment rule to defer and to avoid second-guessing the expertise of business people. Now, that's the good news. There's one other part to this, though. Remember, I said that the business judgment rule is a presumption. It's a presumption. And like every presumption, it can be rebutted. And here's where the action is. Because some disgruntled shareholder who has found some entrepreneurial plaintiff's lawyer to represent them is going to be able to file a lawsuit. And the question will be, can they allege facts in their complaint attacking you and your board members in a way that rebuts the presumption of the business judgment rule? And all they have to do is allege one of two things, basically. Facts that would suggest that you did nothing to inform yourselves. You didn't take any effort to inform yourselves, or you did a sloppy job of it, or you blinded yourselves and didn't consider lots of reasonably available information. In other words, you violated your duty of due care to inform yourselves. Alternatively, and this is the one they most like to pursue, the plaintiff's lawyers will try to make allegations suggesting that you weren't impartial, you weren't independent, you had interests besides the shareholders that you were paying attention to, that you were beholden to some other entity, to some other particular stockholder maybe, to some other affiliate, to some other fund, to some other company that you had an investment in or that you worked for. And so you weren't independent. You didn't make that good faith, honest judgment that this was in the best interests of the company and all of its stockholders. You made a decision that was influenced by this other influence, this other conflict that you're afflicted by. And if they can plead facts that suggest that, there goes the business judgment rule. The judges then are going to say, can't trust you now. Now I can't be sure that you've met that presumption. That presumption has been attacked and rebutted, and now I got to peel away the business judgment rule that protects you, which says that I should defer to you. Now I don't defer to you. Now, does that mean game over, checkmate, you're done? No, it doesn't mean that. It does not mean that. But it does mean now the game has shifted. Now, instead of you being cloaked and protected by the business judgment rule, now the judge is going to look to you and say, persuade me. Persuade me that what you did, the decision you made or the action you took, was entirely fair. And that's a two-part test, folks. Entirely fair means you have to prove that it's not bifurcated. It's two parts, but it's not bifurcated. You have to prove two things. You have to prove to that judge that the process you followed in making that decision, how you went about deciding, how you went about getting informed, how you went about choosing that option, you have to prove and persuade that judge that that was a fair process. And then the second thing, you have to persuade and prove to that judge that the economic terms of whatever it is you recommended, or whatever transaction you said is a good one, or whatever refinancing or recapitalization you thought was in the best interest of the company, you got to prove to that judge that it was entirely fair. The economic terms were entirely fair. Entirely fair to who? Entirely fair to who? Entirely fair to your employees? Entirely fair to your creditors, your debtors? No. Entirely fair to your preferred stockholders? Mm-mm. You got to prove it's entirely fair to all your common stockholders, because that's the focus of Delaware corporate law. Your duties, your care, your loyalty, your good faith run to one constituency. In most instances, only one. And that's that group of common stockholders, all of them. And so you've got to prove that this transaction was entirely fair economically to them, and that it was entirely fair process-wise. Yes, sir.
Sorry to interrupt your question, but don't the directors have that same obligation to preferred shareholders?
Preferred stockholders only share certain common fiduciary duty rights with the common shareholders in certain limited contexts. Otherwise, preferred shareholders have a contract, and that contract is what the court will look to as you negotiated a contract to govern your rights as a preferred stockholder. You have liquidation rights, redemption rights, whatever they might be. That's what protects you. These fiduciary duties run predominantly to the common, who aren't protected by a contract.
So sorry sorry to bring this dialogue. That's really interesting in the context of the private company board.
Yes.
Because for the most part, the board members are preferred shareholders.
Correct. And that's what gives rise to the conflict.
But they will operate, at least the boards that I've been on, the perception is that they have to be fair to common, but they also have the right and the obligation to represent the preferred in those decisions. And what you're arguing is they actually have to accept the contractual elements in the preferred stockholder agreement, ignore preferred, they go only about common.
That's what I'm suggesting to you. That they should look to the contract rights of the preferred, say what they say. And I'm not arguing that the board members could just ignore those and break those contracts. But I'm saying the duties of loyalty and care and good faith all run to the common. They may have some ancillary duties to the preferred. For example, if I'm going to communicate to the common, disclose things to the common, I'm probably going to have to disclose the same things in the same way to the preferred. I've got to treat everybody equally here. But I've got to make sure that when I'm demonstrating entire fairness to that judge, I've got to make sure that he or she knows that I was looking out for the rights of the common, because the preferred have their protections built in, okay? That's the way Delaware looks at this. You've got to make sure the focus is on the common, and the preferred have their rights under their contract. So that's where you are on business judgment. Once that presumption has been rebutted, it's not game over. You can still show fairness, but that's going to be your duty at that point. So let me turn then to the next sort of predicate for this. The premise, I guess it's the premise of the business judgment rule. I mean, the way the judges are looking at this is, this rule is a powerful rule for your protection, but it kind of has got a built-in premise. And that built-in premise is, we're deferring to you because you're experts, but we're also deferring to you because we think you're impartial. You'll be impartial. You'll be independent. You won't be conflicted. You won't have misaligned motives or intentions. So we want impartial decision makers. We understand, we judges, we understand that a business decision can go at least two different ways. It can go at least two different ways. But we think if we've got an impartial decision maker making that choice, if something goes wrong, something goes sideways on that choice, we can chalk it up to human fallibility or just the uncertainty of commercial enterprises. But not so if we think that decision maker who made that choice that now has gone sideways was not impartial, was not independent, had some alignments, some incentives, some conflicts. And this is what really this all boils down to in Delaware. It boils down to something called the dual fiduciary problem. If you are a director and you have dual fiduciary responsibilities, that is, you've got an employer who's put you on that board that you have fiduciary loyalties to, and at the same time on that board you have a loyalty to the shareholders of that company, you are in something of an untenable position, ultimately. And judges in Delaware tend to be unforgiving in this. They tend to be unforgiving if you have these dual loyalties, and it leads to the potential that you let one loyalty interest dominate over the other. And so what they, if you read the opinions, you will see this phrase: if I had a dime for every time I saw it, I'd be in the Caribbean right now on my yacht. They use this phrase: your duties as a director of a Delaware corporation mean you have an unremitting duty of loyalty. Unremitting duty of loyalty. It's meant to just drive home. You cannot consider those other factors, that your employer or the fund that you work for might be better off if this. You can't. You can't serve two masters. You can only serve one. That's the way Delaware approaches this. So this principle of the impartial decision maker is why, if you're on a board where less than a majority, because that's what Delaware looks to. If you got a 5-member board, Delaware wants to see 3 independents, a majority. Because that way the judge can say, a majority made the decision, the majority was independent, I can defer. You're home free, business judgment land. Happy, happy, happy. If it's less than 3, if you only have 2 independents, sad, sad, sad. You're not in business judgment land anymore. Judges are going to say, I can't trust that decision. These people are conflicted. So the judge is going to automatically default to Remember? It's not game over, but it's entire fairness land. And if it's entire fairness land, you had better done your homework ahead of time. Because if you find yourself in entire fairness land, and now you're starting to figure out what you need to do to create that good process, it's too late. It's too late. So you need to do all of that before you get yourself into that spot. So what can you do? Now, the panel earlier today, one of the panels I know was talking about there are certain things you can do, certain mechanical steps that you can take. You can create, for example, a special committee. And that committee of the directors can be composed entirely of independent, impartial decision makers. That's a help. That's a step in the right direction. Just beware. Delaware's vigilant about looking at those people you put on that committee. Make sure they are like Caesar's wife, above reproach. Make sure that there is nothing about their background that can be attacked, because if it can be, it will be. It doesn't mean you'll necessarily lose the battle, but why have to go through the fight in the first place? Pick people for that committee that are going to absolutely withstand any challenge on the grounds of having some contact. They're on the board of Stanford, or they're on the board of this college, or they made a donation to this charity. Avoid anything of that sort, and it'll save you headaches later. So that's one thing. Make sure that that committee, that if you create it, make sure that it's given the authority and the power to make the decision. Because after all, it's the only independent, impartial decision makers you've got. So make sure it's given the authority. Make sure that it has the power to say no to a transaction that's not a good one. Make sure that it has the power to hire good advisors, good independent advisors, financial, legal, who can help it navigate this process. That's one thing the committee, that the panel earlier today mentioned. The other thing that you can do, you can put it to a vote of those common shareholders, those unaffiliated common shareholders, and let them have a veto. As a practical matter, I know the panel earlier today talked about how that really doesn't really work so well, because if the common, for example, is getting nothing, it's going to be kind of hard to get a very good turnout on that vote. So that's going to be the practical issue you're going to have to confront. Or you're going to have to find some way to find some part, as I remember one of the panelists this morning mentioned, finding some way to divert some of that transaction price to the common, so that maybe they will vote for the deal. Maybe they will approve it. That's another thing you can do. So in addition to creating that may, I would emphasize, only may get you back into the happy, happy world of business judgment. If you create the committee and put it to a vote of the minority and they approve it, if you do both of those things and you've set it up right, you can perhaps get back to business judgment land. But if you miss on either part of it, you're not going to get there. You're going to be still stuck in entire fairness. So you have to be a little careful when you set this up. Now, if you're confronted with this reality, that you have a board that doesn't have an independent majority, or suppose it doesn't even have enough to create a committee usefully, and you can't go the majority the minority vote route, is there anything else you can do? Well, my advice to you is, yeah, you can think carefully about how to design your process so that you'll be able to withstand scrutiny under that entire fairness standard. Because as I told you before, it is not an outcome determinative standard. It's not like checkmate if you're in that. I had a lot of cases where I found that they had acted in an entirely fair way. So it can be done. It just means you have to be thoughtful up front, ex ante. Set up a good process. Now, what does that mean? You've heard that word throughout the day, process. That's because judges love that word. Judges love it to death. They eat it up. They love process. Why? Because they're lawyers. And lawyers and laws are all about procedures. So you can see why judges immediately say, now I know about process. I'm an expert in that. Now you're on my turf. You're business people, but I'm a lawyer. I understand procedures. So judges are going to be all over you for how did you set up your process? What did you do? How did you design it? What information sources did you get? Who did you hire to assist you? And did they have independence too? Did those financial advisors or those operational consultants or those lawyers, did they have independence too? Or were they somehow connected in some other ways with those who had an interest in this transaction? So that's the key too. Good process, good procedures to inform you so that you can make a good decision, and good advisors to help you on the path. And don't skimp. I know I've heard this morning about how it's expensive, it slows things up. I understand all that. It's like the Midas muffler guy. You can pay me now or you can pay me later. And the inference is you're going to pay a lot more later. It's better to spend a little now than it is to spend a lot later. Next thing, judges not only love process and eat it up, they want it. They want to see it. So think about how you can give them what they want. Think about that. But the other thing is, how about if you create, well, let me put it this way. Have you ever heard the old story or the old question, if a tree falls in the forest and there's no one there to hear it, does it make a sound? So the question on this side of the law is, if you design an exemplary process, but you have no record to prove it, is a judge going to believe you? Same question. So the next thing judges want to see, besides really good process, they want to see a good record of process. Now that's not easy to do. And this is where a lot of people stumble. They don't create a good record. And that's going to hurt you later on, because then you're going to have to try to persuade that judge to believe you. You're going to have to say, Your Honor, please, I'm telling you the truth. This is what we did. But we don't have any record to prove it. Or what can happen even worse, is that you can have contemporaneous documents about the record, and what you say happened doesn't match up with those contemporaneous documents. You say something later, and that could be years later, by the way. You could be testifying about something that happened 6 years ago. I can't remember what happened 6 days ago, but you might have to. And if you've got a record that's inconsistent with what you remember now, you're in a world of hurt. You're just in a world of hurt. So my advice is, think very carefully, methodically about how to preserve and document. You know, there's an instinct, and I understand it because of the way things move and the speed at which they move, to just call up people on the board, and have quick conversations about what you're going to do. Problem is, there's no record of that. There's no record that the judge can read. So my advice is, make sure as much as you can to have meetings where the entire board is convened. It can be telephonically, it can be in person if possible, but please have meetings of the entire board where you have these conversations about what you're doing and why you're doing what it is you're doing, and have a good corporate secretary who takes very good minutes of those meetings, because the judges read them. They read every single word of those minutes. Moreover, they read your emails. They read your text messages. There was an opinion last month by Chancellor Bouchard where he referred to the fact that one of the directors used an emoticon, a smiley face, in the text message, and the judge said, that sort of implies that the person who sent that was being sarcastic, wasn't really being truthful. So now you have to worry about the emoticons that you include in your text messages. And I can only emphasize this because this is something you need to really bear in mind. When you send email, don't send stupid email. Because it's going to come back. Email never goes away. You can delete it, but it never goes away. Whatever you say will come back and is going to be read by a judge. And it might find its way into an opinion. Chancellor Strine wrote an opinion about a year ago in which he referred to emails among certain people in the case that were making fun, disparaging remarks about a female member of the financial analyst team that they were negotiating with. And he went on in that opinion to say, this is the type of juvenile, almost juvenile behavior of people who have, insecurities and complexes of their own and ought to get therapy for it. Do you really want to read that about yourself? I mean, think about it. So you have to be very careful. But you need to develop this record, and that record is going to be minutes of meetings. And just for the record, I know that there is a dichotomy of views about this, but I fall on the side that more is better, not less. Let me tell you why. Because number one, I know that judges read the meeting minutes. I know they read them. I read them, word for word. And I wanted to see that you were engaged, that you were actually there at a meeting and you were having a back and forth, discussing the pros and cons, considering other alternatives, rejecting certain things because they weren't workable or practicable, and that you were always in the mind's eye of what's best for this company and its stockholders. And if I saw that deliberative process in those minutes, it just reassured me. And that's what all the judges are doing. So those minutes need to not be transcripts. Don't misunderstand. I'm not saying transcripts. But I'm saying they should reflect that you had this engagement, that you were fully engaged, and you were thinking and you were mindful of who your duties ran to. Any presentations that are made to the board, make sure they're attached to the minutes. Letters, correspondence, contracts, whatever you're considering, make sure they're attached to the minutes. It all goes to showing that you were informed and that you had your mind's eye on the right target here, the best interests of the company and its shareholders. So, yes, sir.
It's very common for the minutes to say the CEO presented topic X, pros and cons, factors, a discussion ensued, a decision was made, it was X, and that's it. And it's any avoidance of detail at all, and you're not comfortable with that. So
I'm not if that's a controversial decision, or if that's a decision that's really, a major decision for that company. If it's an ordinary run-of-the-mill business decision of the company, it may be okay. But I'm saying if you're doing, another series of financing, or if you're doing a recapitalization, or if you're doing a sale, I think you need to put in there that there was a deliberative process among the board members. Questions were asked of the financial advisor. Why haven't we contacted this bidder? Why haven't we contacted, private equity people? Why are we restricting ourselves to private equity and not to strategic? Whatever the controversy is about a decision ought to be laid out enough so that the judge knows that, look, they thought about it. Look, they asked questions about it. They asked their advisors. They got answers. That's all that the judge wants to see. He wants to see something that shows what you did. If you can remember all of that, you can trust that the judge will believe you when you tell him that, yeah, we did all that. But if you've got minutes, number one, that sort of reflect it, that's going to help you. 6 years later, when you're trying to remember what you did at that meeting, it's going to help you remember the give and take and what the discussion was all about and why you didn't pursue one particular set of potential buyers. But that's my view. I mean, you'll get some lawyers, I understand, who will tell you the less said, the better. I'm just looking at it from the perspective of where I came from and the world I lived in. Yes, sir.
So, when you said to attach the presentation to notice the minutes, that gets fairly heavy in terms of record keeping.
Yes.
And the minutes books are available for inspection by any shareholder.
Yes.
Frequently, what's being discussed in a board meeting, often there are things that really, we went down, and one of my board members is here. So we went down, a path, and we discussed it, and we said, well, no, we're not going to do that. There's a lot of times in a board meeting that you're spitballing, and it's really not stuff that should be seen by anybody other than the people that were involved in the decision at the time. Because then they say, well, why didn't you do that? I would like you to, you get one disgruntled shareholder says, well, that's what I wanted you to do because that was right for me. So, I mean, on the one hand, I can see when a case comes up, having them available to present, and we do, but attaching them in minutes so they can be inspected by all shareholders.
Well, if inspection rights by shareholders under 220 of our law, Delaware law at least, are limited to that shareholder, and if you're required, if the shareholder, first of all, has made a proper demand to inspect and can show a proper purpose for inspecting, they have to clear those hurdles. But if they can and get access to those documents, you can impose confidentiality requirements on them in terms of their ability to review that and prevent them from sharing it with anyone else.
Right, but they can then breach that confidentiality and make it very difficult
With staff, for example. I mean, yes, there's a consequence, but the problem with that type of stuff is that, and I don't mean to argue here, but
No, I understand.
the problem with that type of stuff is you can cause operational problems for your company.
Well, you may have to then provide for presentations and documentation supporting a particular set of minutes that you think are highly confidential, that you think are potentially able to be abused if they fall in the wrong hands. You're going to have to segregate those. All I'm saying is that at the time of litigation, when the litigation rolls around challenging your action, you should be able to find those, produce those, and give them to the judge. Because you don't want to hide behind the shield of privilege at that point, because the judge is going to be suspicious. You're telling him what you did and that you reviewed this, this, and this. but you don't have any documents that you're willing to let him see that you did that, I think that's where there's a disconnect. And when it comes to litigation, you need to be able to do that.
Well, I wasn't saying that to the judge, I was just saying that putting all that stuff in the board book, we do have it, we have it available, you know, the contemporaneous notes and the decks, but we don't put them in the board book where they're normally for inspection.
Then I don't think you're in harm's way if you do that way. As long as you can ultimately, when litigation does happen, as it always does, you've got them available to produce as part of the production in the discovery process. Was there another question? I'm not sure. So let me just, quickly sort of summarize what I'm trying to suggest to you is that first, as directors of a company, whether it's private or public, your duties and obligations are the same. They don't change. And the best way to gain the protection of the business judgment rule is if it's being made by an independent group of people, a majority of independents. If they aren't, if it's not a majority, for whatever practical reasons you can't get a majority of independents, then prepare yourselves. Prepare yourselves so that in the eventuality that there is a lawsuit and that you lose the protection of the business judgment rule, you've got a good process that you designed and executed on, and you've got a good record-keeping process that will document it, that will help you remember what you did, and that will show the judge that what you're saying you did, you actually did. If you do those things, then I think you're going to find yourselves no longer in harm's way. You may have the unfortunate experience of being deposed and so on, but it won't be as difficult as it might otherwise be. The last point I would leave you with is when I talked about the sort of the mystique of Delaware and sort of some of the disconnects between Silicon Valley and Brandywine Valley, it shouldn't be. Because if there's anything at all that we're confident of in Delaware and in the Brandywine Valley about Silicon Valley and Stanford and other institutions like this, is that you're extremely creative. You're very creative, imaginative people and innovative people. We get that. So let me suggest to you, Delaware's open to that because Delaware's not saying there's only one way to design the process that satisfies us. They'll leave that up to you. You come up with novel and different ways to design the process, Delaware will consider it. Delaware will entertain that. So think about that. And there are ways in which corporate law can be innovated. That's that industry back on the Brandywine Valley. They're always looking for ways to innovate. Why? Because just like in Silicon Valley, they're trying to outcompete their competitors. It's a very competitive business, corporate law. So Delaware's trying to think of ways to do that. And one quick example, or two quick examples, you've all heard of the poison pill or the rights plan. That was a corporate law innovation that came out of Delaware that now everyone accepts and takes for granted. But it was innovative back in 1985. And today, just recently, just a year ago in fact, this institution, Stanford, Professor Grunfest and some others, along with a company headquartered out here, Chevron, they helped Delaware develop another innovation. That corporate law innovation is the forum selection bylaw. A bylaw that a company can adopt selecting a particular forum where all litigation regarding that company's directors, fiduciary duties, internal affairs shall be litigated. Wilson Sonsini represented Chevron, won that case in the Court of Chancery, which said, yes, this is a perfect way for companies to fend off multiple lawsuits in multiple jurisdictions, wasting time and money by fighting off lawsuits in 3 different jurisdictions in 6 different courtrooms. And the Court of Chancery and the Supreme Court have said, yes, that's a new innovation in corporate law. It's perfectly acceptable under Delaware law. So it's another example that I think, it sort of demonstrates for me a lot of the parallels between Silicon Valley and Brandywine Valley. So I hope to keep that going. I want to thank you very much for your time. I don't want to hold up your next panel. Thank you.